There goes your 8 gigs of memory. We're
Yeah.
recording all our breaks.
All right, go ahead and restart.
He did.
Oh, you did?
Yeah, just now. You're good. Go ahead.
While I'm going do-do-do-do-do-do-do.
We got all that.
That's fantastic. All right, we'll take a second. Okay, we're going to talk about unfair claim settlement practices. Now, this is a section on the test that is mainly definition driven. So if you look at this, there's going to be a lot of definitions, director, insurer. So you want to make sure you go through all of those definitions, and it's basically talking about improper claims practices. Any of the following acts by an insurer, if committed in violation of this section, constitutes an improper claims practice. And, this is going to sound really familiar, misrepresentation to claimants or insureds relevant facts or policy provisions related to coverages. Failing to acknowledge, failing to adopt, not attempting to act in good faith. All those things are in here. Most of that is going to be common sense type stuff. So, failing to adopt and implement reasonable standards to assure that things are done in a timely manner based on the state laws set forth. So that's what this section is going to be covering. In addition, we're going to talk about a section on improper and unfair claim settlement practices that says, it set forth definitions used herein for the rules in this division to aid in the interpretation of various terms and phrases. So you're going to see there is a ton of additional definitions here. I'm going to encourage you on this section to really read through and understand the definitions, because the definitions are what's going to be on the test. Here's kind of the highlights of the section though. An insurer who engaged in one of the more following acts or practices shall be deemed to be engaged in misrepresenting policy provisions. Again, failure to fully disclose. No insurance producer shall conceal from any first-party claimant the benefits of coverage. And no insurer shall deny any claim. No insurer shall deny any claim based on the insurer's failure to submit written notice. Again, this is all real basic stuff. What it says in a nutshell is you have to do what you put in your policy that you're going to do. And failure to do so is not fair to the public and therefore an unfair claim settlement. So we don't use the term claim very often, but in any insurance situation, the use of the service typically constitutes a claim, right? So if your roof gets blown off your house, you need to file a claim. You hit a deer coming back from Kirksville, Missouri, and you need to file an insurance
Claim.
Right. All real stuff. I can't make this up. So our service is unique. We don't use the term claim because we encourage the utilization of the service. We want you to use it. So you've got to understand that for the purposes of recognizing test terminology, anytime you use the service, you're making a claim. And you have to be given certain service standards based on what you write as your policy provisions. You're saying, I'm going to do this because you're paying me each month, and when you call, this is what you can expect. When you have this happen, this is what you can expect. Failure to do that is an unfair claim settlement. So we don't think in terms of claims. So for most of you, when you looked at the section, it said unfair claim settlement. Well, we don't have claims. Well, yes, we do. We just don't use that term. So it makes sense?
Yes.
Okay. There are standards put in place for prompt and fair resolution. So for example, if you have an issue with the attorney and you don't feel like you got the right answer, Legal Shield has a claim practice for that. You contact them, they have to respond within a certain number of days. Okay, and they have to respond with a certain person authorized to represent you on behalf, and that's all kind of what this mainly speaks to the insurance division. This mainly speaks to car insurance, auto insurance, those life insurance, those types of things. But you have to realize that we are an insurance company, and as such, every time the service is used, by definition, it is a claim being made. Or an intake number is a claim number. So use that. Just switch out intake with claim, and that's what we're talking about. So you have to make things right or have justification why you didn't. Always in the interest of protecting
The public.
Okay, we can try again. Always in the interest of protecting
The public.
Right. That is the main goal of the Director of Insurance. And as such, the person or entity that oversees all of these sections is the Director of Insurance. Again, this is claims practices and settlement procedures. But make sure you understand what the Director of Insurance does, and it will help you with this section and all sections. So, I have gone through the entire section on claims practices. And we're going to go in section 7 as Missouri Prepaid Legal Service Plan Insurance Law. And we're going to cover that on the next section.